By now you've heard, or we sure hope you have heard, about the campaign to repeal and replace the Private Attorneys General Act, the notoriously bad law known as PAGA. As our members know, the CRA has teamed up with the California Chamber of Commerce, the California New Car Dealers Association, the California Grocers Association, and the California Manufacturers and Technology Association to repeal that law and replace it with one that is far better for both employers and employees. Our ballot initiative, called the California Fair Pay and Employer Accountability Act, is currently circulating for signatures. But some of you have been curious about another front where PAGA is being debated: the U.S. Supreme Court. The justices have begun hearing a case brought by an employer, Viking River Cruises. So if the justices rule for Viking River Cruises, will that help employers here in California? What does that mean for our state ballot initiative then? Will it still be needed? The answer is a loud yes. Our ballot initiative will be needed as much as ever. And no, even if the justices rule in favor of the employer, that ruling will not exactly solve California's ongoing PAGA problem. Let me give you a very short version of what's in front of the U.S. Supreme Court now and how that's different from the ballot initiative here in California. The Supreme Court is examining how arbitration agreements interact with PAGA. Remember, PAGA lets people sue their employers on their own behalf, but also on behalf of other employees and the state. In a PAGA case, the employee is basically standing in for the state, acting as a private enforcer of labor law. In a previous case, the state Supreme Court in California ruled that arbitration agreements cannot be enforced under the Federal Arbitration Act during PAGA lawsuits, since the employee who files the lawsuit is technically representing the state. Since that 2014 ruling, the number of PAGA cases has skyrocketed, and it has been devastating to many small businesses. If the nation's high court decides that arbitration agreements can be enforced, that may be a win for a larger business that has lawyers and arbitration agreements in place. But it won't end PAGA as a California law. In other words, thousands of smaller California businesses will still be subject to the PAGA shakedown. That's to say nothing of the fact that even when a court decision goes the way we hope it will, it can sometimes take years for its impacts to be felt by any person or business, big or small. As for workers who have a grievance against an employer, PAGA leaves them with tiny sums of money, even from a large settlement. Most of the amount goes to the attorneys and to the state. Now, here's a reminder of what our ballot initiative would do. Instead of battling in court or threatening litigation, an employee with a grievance would take the issue to an independent state regulator, the California Labor Commissioner. If voters passed the act, the Labor Commissioner's office would have many more financial resources, $100 million more in state dollars, to investigate an alleged violation of wage and hour laws in California. That's less costly and less time-consuming than arbitration, and it gives the state the resources for enforcement, instead of turning employees into private enforcers. If money is awarded, it would go to the employee, rather than be shared by the employee and the state or shared with the plaintiff's attorney. This would allow workers to continue to have a voice and a path forward in cases when a supervisor may be willfully violating labor laws, but it removes outside interests and leaves these matters for an independent state regulator to decide. In fact, the law would double the penalties currently on the books for employers who willfully violate the labor code. But again, that amount would go directly to the employee, not to outside interests. So, here's an update on the campaign. It now has more than 50% of signatures needed to go to the voters, but we need to gather many more signatures under a tight deadline. The election isn't until November, but the signature deadline is now less than a month away. And the job of signature gatherers is getting tougher, with new measures crowding the field. As we've been saying for months, we need your help, especially now. With other ballot initiatives in the hands of signature gatherers, our cost per signature has doubled. Go to our website by using the link in the description below. There you can donate to our Issues PAC. Obviously, reforming PAGA will be a significant focus of our Issues PAC, but we also know to keep our eye on other industry threats, like a proposal to increase the state minimum wage to $18 and the legislature's AB 257. Your support is urgently needed to address this opportunity while defending the industry from these other threats. And don't forget to visit the Coalition website, where you can sign up to receive updates from the campaign as it moves forward. You'll find that link below as well. I'm Sabrina. That's the news you need to know.